Hello and welcome back to Inside the Contract. We are still on season 2. This is episode 2. Today we tackle one of the most fundamental yet most frequently mishandled procedural requirement in FIDIC contracts, the notice. In FIDIC 2017, notice is contractual gateway to entitlement. Missing the notice requirements can be fatal to a claim, okay? And many decisions and commentaries treat these provisions as strict condition precedent style mechanisms, depending on the governing law and the contract wording. So this episode explains what a notice is, why it matters, how it must be drafted, and the limited and risky circumstances where late notice may be excused. Okay? Under FIDIC, a notice is a formal written communication, clearly identified as a notice, by which one party alerts the other about an event that may give rise to a claim. Okay? It serves a very practical purpose. It ensures transparency, allows the receiving party to investigate, provides early warning before impacts escalate, and prevents surprise claims submitted long after the fact. Okay? The 2017 edition is explicit. A notice must be in writing, unambiguous, and submitted through the agreed communication channels, typically to the engineer, unless the contract designates another party. Many contractors mistakenly believe that emails, site instructions, WhatsApp messages, or meeting minutes automatically constitute notices. They do not, unless the contract expressly accepts them. FIDIC requires something clearly identified as a notice. Many disputes aren't about whether a message was written, they are about whether it was served through the contractual channel and whether it was clearly a notice of a claim. So, an email might qualify if the contract treats emails as an accepted communication method and it is clearly framed as a notice. Okay? Clause 20.2.1 is the heart of the contractor's notice mechanism. The rule is simple but unforgiving. The contractor must give notice within 28 days after becoming aware or when it should have become aware of the event or circumstance. Three major implications arise from this. 1. The countdown begins not when the impact is understood, but when the event first occurs or becomes known. For example, a late drawing is a triggering event, even before any delay materializes. 2. Failure to notify may result in total loss of entitlement. FIDIC uses the term shall, indicating a mandatory requirement, not optional. The engineer's discretion to accept late notice is limited. The burden is on the contractor to prove why the delay in giving notice was reasonable. Okay? It is also to be noted that FIDIC 2017 adds a procedural safeguard. If the engineer considers the notice of a claim was submitted late, the engineer must notify the claimant party within the contractually stated period, with reasons. If that step isn't taken in time, the notice may be treated as valid under the contract mechanism, okay? So these nuances you have to be aware of. And just a word of caution. Many decision makers in various jurisdictions have reinforced this clause consistently, stating that notice is a condition precedent. So, this risks the claim of being rejected based on not complying with the procedure regardless of merits. This is why sophisticated project teams maintain notice logs, dashboards, and automated triggers to avoid missing the 28-day window period. Okay? A valid FIDIC notice is intentionally simple. The purpose is early warning, not submission of the full claim. A compliant notice must contain 1. A clear identification that this document is a notice under clause 20.2.1. Ambiguous emails such as please be informed or we reserve the rights are insufficient. 2. A concise description of the event or circumstance. This must be factual. For example, IFC drawings for Zone C delayed beyond the contractual review period, or engineer's instruction changed retaining wall thickness, something like that. 3. Must make reference to the relevant contractual provisions where possible. Okay, this is good practice, but not always mandatory. The claim does not need to contain quantification of cost, detailed delay analysis, prolongation, disruption, or acceleration breakdown, expert reports, or evidence files. Those come later in the fully detailed claim under clause 20.2.4. The key is to raise the flag early. Okay? FIDIC also imposes procedural discipline on employer claims. In the 1999 books, employer claims are addressed in subclause 2.5. In the 2017 books, clause 20 applies a common claims procedure to both parties. So an employer seeking payment recovery, set-off, or deductions, or other contractual relief is generally expected to follow the claim and notice pathway set out in clause 20, or as amended in the particular conditions. FIDIC also binds the employer through a notice obligation. Under these clauses, the employer must notify the contractor if it believes it is entitled to, for example, recover money, deduct sums, impose liquidated damages, or claim costs due to contractor breach. This is sometimes overlooked by employers who assume they can issue deductions or LDs without proper notice, but under FIDIC 2017, that is not permissible. The employer's notice must identify the event, state the basis of entitlement, and be issued before attempting recovery. This reinforces that both parties must follow the same procedural discipline. All right? One of the boldest features of FIDIC 2017 is its express time bar. The 28-day rule is drafted in absolute terms. Okay? If the contractor does not issue notice in time, and if the engineer does not extend or excuse the delay, FIDIC 2017 treats the notice of a claim timeline as a potential time bar. If the notice is late and the contract's late notice mechanism is engaged, the claimant party may lose entitlement for that event. The practical takeaway is the same. Treat the notice deadline as hard and do not assume discretion or fairness will save it. Decision makers may enforce this strictly. They focus on the letter of the contract, not subjective fairness. Okay? So if we look at some key arbitration trends, for example, not knowing the contractual requirement is never accepted as an excuse. Internal approval delays by the contractor do not extend the deadline. Ongoing discussions or verbal warnings do not count as notice. Even strong entitlement cannot override failure to follow the procedure.
In the GCC, multiple occurrences have supported this rigid approach, a trend aligned with FIDIC, global FIDIC interpretation. Here is a common pattern I have seen repeatedly on major projects. The team documents the problem in reports and meetings, but never issues a clearly framed notice of a claim through the contractual channel. Months later, when the fully detailed claim arrives, the other side rejects it on notice time bar grounds, regardless of how real the underlying delay was. So in FIDIC, procedural discipline is an important technical, and it's as important as technical entitlement. Okay. Okay, there are rare circumstances where late notice might still be accepted. If the employer acts in a way that clearly indicates it is waiving the notice requirement, for example, actively engaging in full claim evaluation without objecting to the late notice, directing the contractor to proceed with mitigation while acknowledging the claim, or explicitly stating that notice timing is not an issue, then decision makers may consider that the employer waived the strict time bar. However, and I be very careful, waiver and estoppel are extremely difficult to prove. The contractor must demonstrate, clear conduct, repeated and consistent behavior, and reliance on the employer's action. Most tribunals default to the contract wording, meaning never rely on waiver, always issue notice. Again, though, I must stress and repeat, this will depend on the governing law and contract wording. The argument regarding a waiver, estoppel, or prevention are going to be fact-specific, hard to prove, and never a safe strategy. The safest strategy is simple: issue the notice on time. The best contractor teams avoid notice disputes entirely by embedding robust internal procedures. They use templates labeled notice under clause 20.2.1. They submit immediately, even if the impact is unclear. Waiting never helps. They track time bars using dashboards or contract management software. They train site engineers and construction managers. They are the first to detect claim events. They send notices through the contractual channels, not WhatsApp messages, not informal email groups. They document the event from day one, so the eventual claim has continuity and evidence. And modern complex projects, especially giga projects with aggressive schedules, early warning is essential, not only for entitlement, but for collaborative risk mitigation. Okay? So just to close, notices are the gateway to claims under FIDIC 2017. They preserve rights, create transparency, and protect both parties from uncontrolled risk. Too many contractors lose otherwise valid claims simply because they failed to notify in time or in the correct form. Mastering this procedural step is essential for anyone involved in the contract administration, project controls, or engineering leadership. Okay? Okay. By this, we come to the conclusion of episode 2. In the next episode, we will explore exceptional events, how FIDIC 2017 reshaped the traditional force majeure concept, and what that means for today's projects.
Okay, thank you for watching, and I will see you next time. Thank you.